Welcome to another edition of World Talks here on TVP World. I'm your host, Benjamin Lee, and please join me and my guest on this next interview. In March, the Council of Europe adopted the European Convention on the Profession of Lawyer, the first binding treaty to strengthen the independence and protection of legal professionals. Poland was among the first to sign it during the presidency of the Council of the European Union. Joining us today on TVP World is Alicja Jagielska-Burduk, Chairwoman of the Foreign Affairs Committee of the National Chamber of Legal Advisors and a key voice in its international promotion. Hello and welcome to TVP World.
Hello, thank you. Thank you for inviting me. Indeed, the convention, the Luxembourg Convention, was called on multiple occasions as a milestone for justice, as a new chapter, because it's indeed the first international treaty that aims to protect lawyers, protect their security, safety, and independence. Obviously, before there were some soft law instruments by UN, for instance, the UN principles, but now this is kind of a new international instrument that we are so proud of. It has been opened for the signatures during the Polish presidency, and Poland was among the first countries to sign. It was just before the session of Committee of Ministers of Council of Europe. And what should be noted, in June, World Justice Forum was organized in Warsaw, and the outcome document, the Warsaw Principles for the Rule of Law, also mention the role of the convention in the very principle number 8 on security, integrity, and independence of lawyers. Governments are encouraged to ratify, and then implement the convention, as well as to join forces when the lawyer's profession is not secure, it's not autonomous, because the convention guarantees not only security for lawyers, but also for bars, for law associations, which are autonomous, and we as a bars at the national and regional level are coordinating the organization of the lawyers' profession system.
Right, like I mentioned, there were some measures before to try to safeguard the profession, but this is the first time that there's something binding that's actually being signed. What do you believe is the single most important innovation of this convention that distinguishes it from previous attempts and other non-binding instruments when it comes to helping the legal professionals?
Of course, it's first binding instrument. For now, there are 23 countries that have signed the convention. When it is ratified by 8 countries, 6 from Council of Europe and 2 other countries, then the treaty enters into force. And what is the unique thing? It's the fact that there is a system created by setting up a committee of experts called GRAVO, which is responsible for coordination, monitoring of the convention's implementation. That is the periodic reporting by states, but also the emergency system when the GRAVO is informed by civic society, international organizations, or bars, lawyers about something wrong, not lawful going on in respective countries. Then the study visit is being organized, that is followed by the report. For us, it's important also because it guarantees the autonomy of bars. As a member of the National Bar of Attorneys at Law and chairing the Foreign Affairs Committee, during our meetings with international partners, with international organizations, we discuss the autonomy of our bars very often. For instance, what should be emphasized is the role of Poland in drafting the convention, as well as the role of CCBE, that is the Council of Bars and Law Societies, which all started in Poland, because 10 years ago, when Maria Ślązak was president of the CCBE, this Council of Bars and Law Societies. There was a meeting session, General Assembly of CCB in Gdańsk, the Cradle of Solidarity. And then the idea of such an instrument appeared, and it took long time because, as we all know, to draft the international document, it's a whole process. There should be a trigger moment, there should be a committee, working group installed at different levels, and this moment was also recalled in May by current president of the CCB, Terry Wickers, while his official visit in our bar, where he met with our president, Włodzimierz Chruścik, and we all discussed the role of the convention, the role of Poland and Polish lawyers during drafting it. What cannot be omitted is also the fact that CCBE, on behalf of over 1 million lawyers, because there are bars from 46 countries, European countries, represented, and was a key observer during the drafting process and had and influenced the content of the convention, of the wording. Our bar is very involved in giving broad visibility of the convention, as well as we are deeply committed to disseminating information. For instance, in May, we had an official visit of Claire Ovi from Human Rights Directorate, Council of Europe, where officially we discussed the role of the convention, how our bar can contribute to it.
Right, it's definitely a very kind of long and strenuous process to get it done. But I'm more curious about the practical level. This convention also mandates that lawyers and their associations must be free from, quote, improper hindrance or interference. Can you give us any example of where this could make a tangible difference for the practitioners?
Yes. When lawyers are being targeted, when lawyers are being attacked or detained or unlawfully prosecuted, then the GRAVO, if already set up and the convention is already in work, can prepare a report and recommendations. Also, I must say that this convention covers all the cornerstones of the attorney's client, for instance, privilege, the communication, the access to justice, the access to law, because we all know that lawyers are the pillars of the rule of law. For instance, when the lawyer is harassed, or the lawyer is being abused, or there are some unlawful attacks, then they can be notified, and countries, while being parties of the convention, are obliged to implement certain rules and to make sure that such things are covered, and that lawyers are safe, and they can assist all clients.
Right, it does sound very, very promising, but in practice, how will that look? Because in jurisdictions where lawyers are, like I mentioned, under threats of harassment or a disciplinary misuse or even political pressure, how realistic is it that this convention will change some behavior on the ground?
So it's a long-term strategy. It's not like the wash and go that you have at the very first moment. But in all the claims, in all the complaints, the lawyers can refer to the convention, to its values. Also, if the country is a party of the convention, the country is obliged to implement the values. So for now, it's the moment that we are giving the visibility of this new convention. We are waiting for new signatures, ratifications, and then we have to proceed very carefully with the convention being in force, and with the setting up of the new convention's bodies. Because it's like with all international treaties, that it's not for 10 years, 5 years, but it's for the future generations what we are working on. And even before international courts, the fact that this convention exists is also important, because we know how it is all proliferating, how we can notice cross-fertilization of all international documents. So this is the milestone. And now how it will work, for instance, when the license of the attorney is terminated without a right cause, then the attorney can also refer to Gravo.
Right, so instead of looking at it as a be-all and end-all type of convention, this should be seen as a more big step forward when it comes to establishing a milestone.
Indeed.
Thank you so much for your input and insight. Really appreciate it. And thank you for tuning into this edition of World Talks. But for more news, update, and commentary, please stay tuned to TVP World.